All right. Good afternoon, everyone. Welcome to the webinar being put on by McGuireWoods. We are here this afternoon to talk about expert testimony and the new Rule 702 that went into effect on December 1st, as I'm sure everyone remembers from the fireworks and the dancing in the streets and everything like that. Let's get started off by introducing our panel. So I am joined today by Brian Schmalzbach. He is a partner in McGuireWoods Environmental and Mass Tort Litigation Group. Brian specializes in appeals, class actions, and high-stakes dispositive motions. Also joined by Lucy Wheatley. Lucy is the co-leader of our intellectual property practice group, and she focuses on high-stakes trademark, trade dress, copyright, and false advertising disputes. And I'll be sort of moderating a little bit here today. My name is Greg Duboff. I'm a trial lawyer and commercial litigator covering a pretty wide band of substantive areas, but focusing on business torts, contract disputes, and also wrongful death claims. So thank you for joining us today. Here's our agenda of what we're going to be talking about. So we're going to start off, obviously, by talking about the changes that happened, what those changes are, and why the changes were made. And then we'll talk about recent experiences that we've had in cases or in hearings under the new Rule 702, and then also some recent case law that gives us a little bit of a preview into how courts are handling the change. And then to close up, we'll talk about different sort of strategic implications from the new Rule 702. A lot of it focused on depositions, but also motions to exclude experts. So we'll talk about how to go on the offense, how to attack the other side's experts, how to go about and think about defending our own experts' testimony, and then also how to incorporate the new rule into motions to exclude expert testimony. Before I go any further, everyone should be able to see a Q&A box. I think all the attendees, your volume is muted because I think in experience has shown that would get way out of hand. So if you have any questions or any comments or anything like that, we'll have a time at the end, but please feel free to drop those in the Q&A box, and we'll certainly try to address those as we're going through the presentation. And if not, we will get to them at the end. So moving on, this is as of December 1st of last year. Here is the new Rule 702, and we have the changes that were made to the rule highlighted. So a witness who is qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of an opinion or otherwise. And then the new language is, if the proponent demonstrates to the court that it is more likely than not that, and then you have the four familiar factors, A through C are the same, but the other change came in subsection D there, which is the expert's opinion, and then this is the added language, reflects a reliable application of the principles and methods to the facts of the case. So that's a short version of what the changes are, and I'm going to toss it to Brian to sort of discuss the rationale behind these changes.
Thanks, Greg, and happy Thursday to everyone. I should probably put in a disclaimer at the beginning that I am an unrepentant class action defense litigator, and so the perspective you're likely to hear from me, whether I intend it or not, is of a defense litigator. But it's not all bad news for you plaintiffs' lawyers out there. Lucy does a lot of plaintiff side work in her practice, and so I'm sure she will correct all of my overstatements and give you a good balanced perspective. But let's start with what these changes are really getting at. There's two, and I want to walk through them at a fairly granular level of detail because they're doing some important things. The first one is in the preamble. If the proponent demonstrates to the court that it is more likely than not that, colon. So this is dealing with the burden of proof, but it's addressing it in three different ways. The first way is to answer the question, who bears the burden? And clearly, who bears the burden under the revised rule is the proponent of the purported expert evidence. And what does that mean? It means that expert evidence is not presumed to be admissible. That would essentially put the burden on the opponent of the evidence. This is what the committee describes as a clarification, but it's a clarification with some awfully big teeth. There's some very spicy language that came out of the committee note, but also out of the reporter to the advisory committee, who told the press before the rule came out that this was designed to correct, quote, wayward courts. And during the drafting process, he said, what we're trying to say with this amendment is we weren't kidding. We really mean it. Follow this rule or else. So when we talk later about what to do with this change, it's very helpful to get the point across to courts that this is clarifying to an extent, but it's clarifying, it's a necessary clarification that courts were getting this wrong. And so this is really meant to fix that. And one of the things that courts were consistently doing wrong that the committee was trying to correct was assigning in expressly or implicitly the burden on the opponent of the evidence. So the second question after who bears the burden is how heavy is that burden? And here again, the text of that change in green on your screen answers that. It's just a more likely than not standard. So it's the same standard that applies to most evidentiary predicates under Federal Rule of Evidence 104A. There's no burden at all on the opponent of the evidence. And there's certainly not the sort of burden that some courts had placed on the opponent of the evidence to show that this is some exceptionally unreliable element or exceptionally unreliable proffered testimony. Instead, it's the proponent of the evidence who bears the burden, and the burden of proof is by a preponderance of the evidence. Now, the third question that this change answers, albeit in a bit of an indirect way, is on what elements does that burden lie? And the answer to that is governed by the colon at the end of that. Each of those 4 subparagraphs is subject to the proponent's burden of proving it by a preponderance of the evidence, by a more likely than not standard. And so those 4 elements are helpfulness, that it will help the trier of fact to understand the evidence or determine a fact and issue. 2 is it's the basis for that testimony, that it's based on sufficient facts or data. 3 is the methodology, that the testimony is the product of reliable methods or principles. And 4 is application, that the expert's opinion reflects a reliable application of the principles and methods to the facts of the case. And all 4 of those have to be proved to a more likely than not degree. The committee was particularly sensitive about 2 of these that courts had been, in the committee's view, a little soft on. And that's the sufficiency of the basis for the opinion and the reliable application of the expert's methodology. Some cases, as we'll see in just a moment, had said that there's a heightened standard for the opponent of the evidence to prove these to an exceptional degree that basically presumes that testimony is based on sufficient data or is a reliable application of the methodology unless the opponent of the evidence proves to a very strong degree that that is not true. The committee here is making clear that all 4 of these are 1, the proponent's burden of proof, and 2, just by a preponderance of the evidence. You can think of these latter 3 elements as being kind of like a road trip. You have to have a reliable car, and that's your methodology. You have to have a reliable basis for the facts that goes into your methodology. That's like the gas that you put in your tank. And then the application of your methodology based on sufficient facts or data, that's like staying in your lane. So we want to make sure we have good fuel, we have a reliable car, and that the car stays in its lane. And that is the core of the change to Rule 702. So Greg, we can, I'm sorry. And then the second, sorry, Greg, go back to the previous slide. The second change that the committee made is in Part D, which specifies that the expert's opinion has to reflect a reliable application. As I said, this is the stay in your lane requirement. It's not enough for an expert to have a methodology that's reliable as applied to certain areas, but not shown to be reliable as to other areas. So just to take a simple example, if you have an antitrust expert who can reliably apply sufficient facts and data about the market for RVs, it does not follow that that same expert could reliably apply his data and his methodology to the market for commuter cars. They're different things, and this is designed to make sure that the expert testimony that reaches the jury is connected to sufficient data and connected to a reliable methodology as to every output that the expert offers as his testimony. The committee explained this in words that I think are going to show up in a lot of briefs. The committee emphasizes that each expert opinion must stay within the bounds of what can be concluded from a reliable application of the expert's basis and methodology. That's going to show up in a lot of Rule 702 motions, I predict. And the committee also stressed that the judicial gatekeeping for expert witnesses is essential because of this particular reason, that jurors may lack the specialized knowledge to determine whether the conclusion of an expert goes beyond what the expert's basis and methodology may reliably support. So this is a key part of the district court's gatekeeping role, according to the committee. Now we can head to the next slide, Greg. So this slide offers a few recent cases that are prime examples of what the committee considered doing the wrong thing. In all of these cases, courts say that when we're looking at the bases and sources for an expert's opinion, as opposed to the expert's methodology, so when we're looking at the gas as opposed to the car, that there's not a heavy burden on the proponent at all. In fact, some of these courts suggest that it's really the opponent's burden to prove to an extraordinary degree that the bases and sources for the expert's opinion are so unreliable that it should be excluded. And what the committee's change to Rule 702 does is it says these cases are wrong. These cases are flipping the burden, they're elevating the burden, and that is not how the rule is supposed to be applied. And going forward, it is clear that that is not how the rule will be applied. And so with that, the committee called out as a particular problem with this is forensic experts, where, again, forensic experts might be qualified to offer testimony, but that the bases and sources for the forensic experts' opinions have to be reliable, but also when they're applied, they can only be applied to the degree that is reliable. So an expert can't use a reliable methodology to say without a reliable basis that it's 100% certain that something happened that way when that expert is relying on data or when that expert is relying on a methodology that doesn't get you to that level of certainty. Next slide. And so now I'll share a quick story that I think is a great example of what the committee was worried about when it came to the bases and sources of an expert's opinion. Greg and I both dealt with a case relating to the airline industry. And we dealt with an expert who was trying to price flights in the airline industry, sort of regular commercial flights that any of us might normally fly on. And as part of the expert's burden, the expert wanted to show that he had a reliable model of that market, a model that included both supply side factors and demand side factors. And as part of the supply side factors that the expert wanted to use to construct a viable market price, he needed to testify as to what the marginal costs of various flights would be. And so here the expert needed to come up with some basis for saying that the marginal cost of flight X was Y dollars. And the expert dutifully in his report offered some citations for what various marginal costs would be. And we got to ask him in his deposition, well, where did these marginal costs come from? You're not an airline economist. How do you know that this is true? And he said, oh, well, it's quite easy. I Googled airplane flight marginal costs. And the first thing that came up was aircraftcostcalculator.com, a website that, with due respect for the good folks who put it together, looks like a middle schooler could have assembled it. And so we then asked him, okay, well, you didn't independently derive these costs. How did aircraftcostcalculator.com derive these marginal costs? Oh, gosh, I don't know. Well, how do you know that aircraftcostcalculator.com has reliable marginal costs? Well, gee, I hadn't thought about that. Under the new rules, those answers should have made his expert testimony DOA, because he can't establish that the bases and grounds for his opinion, which is based on these marginal costs, was reliable. He just simply didn't know. And since the proponent of the testimony, the proponent of this expert, have the burden of proving that it's more likely than not reliable, those two answers would essentially have admitted that his testimony based on that data is not reliable. And so this is a prime example, in my humble opinion, of the kind of thing that courts now have to evaluate much more strictly and make sure that when you're looking at the inputs that go into an expert's methodology, those inputs are themselves bases and grounds. And so be very careful going forward to test your own experts and your opponent's experts to make sure that their bases and grounds are reliable in a way that this guy's was not.
Thanks, Brian. And now we are going to pass it off to Lucy, who's going to talk about kind of the early tea leaves that we've gotten, both in her personal experience, but also some things that we're seeing kind of percolate up through the case law. So take it away, Lucy.
Great. Well, first, thank you to Brian for referring to the advisory committee note as spicy. That's a first for me, hearing an advisory committee note described that way. And also, thank you for pointing out that, yes, for those of us who do regularly represent plaintiffs, this rule change seems like it could substantially increase the difficulty of getting experts in and preparing expert reports. And early cases to come out applying this revised rule do point in that direction. Certainly, you have the Fourth Circuit issuing a recent opinion in the Sardis case that the judge does need to make findings as to reliability. They cannot just say, oh, the criticisms go to wait, let's go to trial. So the judges are going to be expected to get down into the weeds and really make a determination here. And recent district courts have done just that. In this Hickox v. Historiale GRP Inc. case, which is quoted up there, the judge cited the new rule and did a very detailed analysis of the expert's report and its admissibility. The report at issue in that case concerned whether a forklift was designed in a manner that was unsafe or unreasonably unsafe. And he also, the expert, opined on whether there were alternate designs. As Brian correctly predicted, one of the main issues with the expert's testimony that the judge pointed out, and the expert was ultimately excluded, was that while the expert did have significant engineering experience, he had significant safety experience, he did not have expertise in forklifts specifically. And the judge found that there was not enough of a connection between his particular expertise and the really specific expertise needed to opine on whether the design of a specific forklift was unreasonably unsafe. The judge also in that case, which I found very interesting, was not going to let in the expert's testimony as to alternate designs, even though in appendix he did provide pictures of alternate designs that he said were safer. and described some potential alternate designs because, as the judge pointed out, the expert did not actually propose a specific alternate design and did not produce an alternate design. He merely sort of theorized about designs that, would be safer. The judge also pointed out that the expert had never himself designed a forklift. Now, I think the issue for proponents of expert reports is this does appear to set a very high standard. And the counsel offering the expert in this Hickox case pointed that out and says, you're asking for, a very, very specific type of expertise and, what could be a very expensive proposition if to offer an expert opinion on alternate designs for forklift, you've actually got to design a forklift. Certainly if you are the party offering the expert report, particularly as a plaintiff, if you're really trying to, belts and suspender these things and make sure you meet the standard, the cost of the expert report could be very, very high. Certainly this also points to you need to find your expert very early because you've got to find someone with very specific expertise, and there may not be any out there. Another case that illustrates how this new standard was going to be applied is the Burtis v. Cottrell Inc. case. In that case, the expert was there to opine on whether a person who loaded trailers' injuries were related to the design of the way a winch was pulled on the trailer by this person year after year, such that he had repetitive strain injuries to his arms. And while the expert did have expertise in ergonomics and in the industry, he put in his report a lot of, frankly, lawyerly statements about how the individual who was injured by the trailers, based on his experience, would have known how to load these things. And he didn't really connect the dots in terms of what methodology he was applying or, frankly, why he could make statements about what the individual defendant would have known. Now, this is a pretty common practice for plaintiffs. They have their experts act as a mouthpiece for their arguments in the case, and in the past, frankly, courts have often allowed it. So this does seem to indicate that if you have a judge who is paying attention to the rule, they may feel that they now have to put a stop on that sort of attorney argument getting into expert reports. I think another lesson from the Burtis v. Cottrell case is the expert in the report had used statements about how, based on his reliable methodology and, various scientific principles, the torque on the loading device was not unreasonable, or et cetera, but he didn't show his work. To the extent he had actually done any mathematical analysis, he didn't include that anywhere in the report. And the judge seized upon that very specific scientific, technical sounding language and said, you cannot show that this is reliable and should get past me as the gatekeeper when you didn't, show the basis for this statement. So, I think this case also points to the fact that litigants may have to get their experts to write much better reports, frankly, than their experts are used to writing, particularly experts who have been in this business for a long time and maybe have sort of a standard idea of how reports should look. There needs to be sort of early warning to these folks that you're going to have to put more work into this than maybe you ordinarily would. If we could go to the next slide. I wanted to talk a little bit about what the new standard means for Daubert hearings and some recent experience I've had with a Daubert hearing under the new rule. So I think one lesson here for Daubert hearings is it may make it more important that you request one. If your judge will let you have one, and in fact, maybe even push your judge to say, to really properly explore the relevance, the reliability, we need to have a Daubert hearing. Potentially, if you're the one proffering the expert report at the Daubert hearing, you can, save it by giving your expert a chance to connect the dots if the report itself didn't do so particularly well. You also have a chance to take out the other side's expert by showing very clearly to the judge that they cannot answer basic technical questions about how they came to their conclusions. When we had a recent Daubert hearing, our judge expressed that they really wanted to understand, based on the new standard, where the line was between reliability and weight. And our judge indicated that they did not think that was clear, and that it frankly called into question not just past case law applying Rule 702, but also, frankly, certain types of experts who may have been generally admitted under previous conceptions of the rule, but perhaps their methodology does not really meet generally accepted standards for reliability. With Daubert hearings, come a lot of challenges and considerations unique to live testimony. One thing with the Daubert hearing is you've got to think carefully that it's about relevance and reliability. It is not about credibility. Credibility is what is left for cross-examination. But the Daubert hearing is for connecting those technical dots for the judge so they can feel comfortable letting the evidence in. And so you've got to take a very methodical approach and really spend a lot of time working with your expert to not just rely on charm, but actually lay out the steps they took in their analysis. On whether or not you push for a Daubert hearing, I think it's also important to assess your expert's fit with the judge. Is your expert good at testifying? Are they prickly? Sometimes technical folks can be excellent in their field, but maybe they are not the best at interacting with opposing counsel or judges. Finally, I would say one additional consideration specific to Daubert hearings and the new rule is think seriously about a rebuttal expert who can not necessarily have the burden that the other experts do of proffering a technical theory, but can really almost be your Daubert witness who can talk about why the other side's experts' methodology is not reliable and really guide the judge in this. And they can do it in a way that possibly your counter expert who maybe has to offer an affirmative theory, is a little hamstrung because they, don't want to have mutually assured destruction and have themselves also be excluded. Whereas a purely rebuttal expert, has a lot of freedom to really just lay out the inadmissibility case for the judge. Greg, did you want to talk about taking expert depositions?
Yeah, thanks, Lucy. Before we get there, thank you. We've got a couple questions, so I'm gonna toss it to Brian in a second. But let's see. One of the questions is, if your opponent does not move to exclude your expert, do you still need some preliminary proceeding to qualify the expert, or just establish admissibility under the rule during your direct examination? I think my take on that would be, like every other rule, or most rules, I should say, the other side can forfeit it, right? So if you have a piece of evidence, if they don't challenge the authenticity of the evidence, then you don't necessarily need to show that it is authentic. So I think the same would apply for expert testimony. If the other side doesn't challenge it, I think most courts would find that essentially they have forfeited any objection as to its admissibility, at least as to the jury hearing that testimony. And then obviously you can, the other side can do what they want to do on cross-examination. So I think that would be the case. I would highly recommend against getting past the Rule 702 motion deadline and then trying to sneak in a challenge to their expert testimony in a motion in limine, close to trial, because most judges will throw things in the general area of your head if you do that. And then another question: has the new standard been applied differently for bench trials and jury trials? I did see that when I was poking around the cases, and this, I think, I wouldn't expect this to change a whole lot with the new rule. The standard was always applied much, much more loosely when you're talking about a bench trial, because the whole point of Rule 702 is that the court serves as a gatekeeper as to what should get through to the jury. So if the court itself is the trier of fact, it doesn't really need to be the gatekeeper for itself. And then even if there was an error as far as admissibility, I mean, certainly even if it's a bench trial, you could have an issue on appeal challenging the credibility or reliability of the expert testimony, but I don't think the mere fact that it was deemed admissible would be a very viable appellate issue. Before I get into the next section, I'll toss it to Brian. There was a question with our aircraft cost calculator.com example. Brian, the question is, what would that expert have needed to show, in your mind, to sort of get over the hurdle that they need to get over under the new rule?
Yeah, thanks, Greg. But actually, before I get there, just to follow up on the first question you answered, there is a sentence in the committee notes that answers this directly, and you're right, of course. The committee said, nor does the amendment require that the court make a finding of reliability in the absence of objection. So you're completely right. The ordinary forfeiture rules apply. If you don't object to the admission of evidence, then you forfeit that objection, and the court won't be reversed for failing to exclude something you didn't ask to exclude. But turning to this question, which is a great practical question about, well, what would my expert, not a hypothetical expert, this is a real expert, what would he have had to do to make his testimony admissible? So I don't want to oversell what the new rule requires. It just requires proof by a preponderance of the evidence that the basis that goes into his testimony is reliable. So I would start by knowing where this website got the data. That would be a great start. If the website got the data from some, I'm just hypothesizing here, some FAA source that is routinely relied on by airlines and treated for business purposes as reliable, I think that is probably sufficient to get over the hurdle for this requirement of the amended Rule 702. And there's a follow-up question about, what about databases which may be well established but which use proprietary methodologies? Again, I don't think there's anything magical in this new rule that is supposed to make it impossible to get testimony in. And so if my expert were relying on something like that, on a proprietary but well-established methodology, I think what I would do is try to indirectly prove that it's reliable by showing, well, who else relies on it? Do airlines rely on it? Do airports rely on it? Do suppliers rely on it? Does the government rely on it? And show that all of those who rely on the data have experience or independent analytical capabilities that provide some assurance that it's reliable. Now, of course, the opponent of that evidence could try to impeach that testimony and show, no, there's holes in that database, there's errors in the coding, and so forth. But that's where I think that battle would likely be fought.
Great. Thanks, Brian. So we're going to now go into a little bit about sort of how this all shake out during discovery as we're moving forward, and some thoughts to keep in mind during that process. So I'm going to talk about just some some approaches and some strategies to taking an expert's deposition. And so the three kind of main headings that I'll be addressing are how to research that particular expert that you're going to be deposing, how to do research on the specific topic, the subject of that expert's testimony, and then how to go about formulating your strategy for a particular deposition. So starting with individual research, there are some good resources out there. And again, this is just to find out what has this particular expert done in the past. Westlaw has a really good piece of gear. It's called Expert Evaluator. If folks have not used that, and then you just go into Westlaw and type Expert Evaluator and it'll come up. And what's nice about this tool is you enter the expert's first and last name, and then it searches. If it's a common name, it'll sort of have their subject of expertise there, so you can make sure you're picking the right one. And what Westlaw has done is it's pretty much scrubbed all of the available federal, definitely, but also a lot of state court records and pulled everything that they can find on this expert. So this would be certainly any time that expert has been mentioned in a judicial ruling, which would most of the time be when their testimony has been challenged. So it's a really quick way to isolate when that expert has been excluded or not. But it will also pull their past CVs. It'll pull their past reports that they've issued in other cases, and it'll pull past deposition testimony. So basically, if their report or their deposition testimony or their CV has ever been slapped onto a motion, this tool does a pretty good job of finding it. There's also PubMed that's more in the medical, med-mal arena, but that can also obviously be helpful if you have a doctor, a medical expert who's talking about injuries or recovery or things of that nature. You can see what that expert has written, what they've published on those topics. Just something to keep in mind. This it might be a little bit counterintuitive. I know that whenever I do one of these expert searches on Expert Evaluator, I'm always excited to see, has this person ever been excluded before? And that's important, and that's fine, and that's good. But also what I found is that expert witnesses that have been excluded before, they are always loaded for bear. That's the case that they know more about than any case they've ever worked on, because they get asked about it at every single deposition. So they're going to have a really ready recall of the facts. They'll make something up and say, oh yeah, they turn into criminal defendants. They say my lawyer screwed me. They didn't file any opposition to the Daubert motion. And so those are not always actually the best ways to attack the expert. What I've actually found, and I have my helpful peacock here, if you can find a report or a deposition where that expert sort of sailed through with flying colors, that can actually be a really good way to attack them. Because a lot of time if you find a case where their opinion actually was reliable and they did have sufficient, facts or data to come up with that opinion, a lot of the time they tend to show off and they say, oh, look how many different ways I can calculate this, or look at how many different ways I can analyze that. We apply these principles in a situation like this. And then, hopefully for you, your case is a bit further afield from that ideal case that they've worked on in the past. And so showing the steps they've taken in their own analysis in the past and showing that they can't actually do that analysis in this case, either because it would give them the answer that they don't want, which I've certainly come across, or there just isn't enough information to do the same analysis that they've done in the past. That can actually be very helpful. And as I mentioned, they're not usually ready. They're not usually ready to be called out on those cases where their testimony just sailed through with no one really questioning it. And so it can be pretty helpful to pose this to them. Hey, do you remember this case? If not, you show them their report or their deposition. And you said this was true. Would you agree that still has to be true, even in this case? And that can be a good way to sort of knock them off balance. The other thing with looking at these past reports and deposition testimony is, experts, are human just like all of us, but experts give deposition testimony more than anyone else in the world. And so if you're able to look at their past depositions and their past reports, you can sort of pick up on patterns. What do they fall into? When you challenge them in a certain way, where do they go to? I had one expert who just, every time he was challenged, he would always raise out of the blue this random expert that had done, or this academic whose research he was very fond of and things of that nature. And so I was able to find studies from that researcher that actually supported us. And sure enough, when I pushed him on this point, he brought up this guy's name, and then I was able to show him, research from that guy that he had never seen, and it put him in a pretty tough spot. So just seeing those things can really help you develop your strategy about the best way to get after this expert. So then now talking about topical research, how can you learn about what you're talking to this person about? And the best research there is just the best resource is to lean on your own expert that you have in that field. They are going to be a great shortcut to provide you with the materials and the resources that you should be looking at to get yourself smart on this area of study. Obviously, you're not going to get to the point that you know more than the other side's expert, but you can certainly get to the point where you're dangerous enough and you understand enough that you can question them. And then certainly not only just general resources to get yourself smart on the issue, but your experts, kind of the best resource to identify the holes in the opposing expert's analysis, provide you with studies or research that disproves it, and things of that nature. So the other thing with topical research is, before we talked about, look at what courts have said about this particular expert in the past. And when you sort of broaden that out, look at what courts have said about experts of this kind in the past. And so even if your expert has never been excluded, you can usually find a court that has excluded some expert like that in the past. And a lot of the time, what they say can be very helpful. So this is, an example that I had. This was in Florida State Court, but this is a Florida Supreme Court decision, and it just says that basically this was a damages expert, right? And so the Florida Supreme Court decision said that someone can provide expert testimony on like the level of trauma that a family member has experienced in a wrongful death case if they have treated the survivor or reviewed records concerning a survivor's treatment. So that was very helpful because in our case, this damages expert had interviewed the survivor, but had not actually provided any treatment and had not reviewed any of his medical records. So basically went through a long sort of diagnostic interview, but didn't actually provide any treatment. And so I was able to use this exact language in putting together my questions. And I, well, did you treat him? Oh, no, I didn't treat him. Okay. And you didn't review any of his past records either. No, I didn't do that either. And then, okay, they've sort of just walked themselves right into the standard that applies for why that testimony would be admissible. And then kind of that once you kind of do those things, then you need to start putting together your strategy for how you want to go after this expert. And the first thing to do here, sorry, I see there's is the expert evaluator website public? It's open to the paying public, I'm sure, but you need a Westlaw subscription to get into that. So hopefully that answers the question. So the first step when you're preparing to kind of actually starting to write out your outline or whatever you use to walk into an expert deposition is you have to figure out what your goals are, right? There are going to be some experts, obviously, that their methodology is sort of so by the book, it's so well established, and maybe they're so well established that you're not really going to challenge their credentials. You're not going to challenge their methodology. And so the first thing to decide is, are you even going to try to get this person excluded? Okay, because a deposition where you're going to end up trying to get the person excluded is probably going to look a lot different than a deposition where going in that that's just not going to be possible. If you're trying to get them excluded, you're going to focus a lot more on obviously the holes in their analysis, the things they didn't do, sort of the assumptions that they made, things of that nature. But if you've kind of decided that that's not the best way to go, and that could be not just because you think you would lose, which is important, but also there are some situations where, hey, they have their expert on this topic, we have our expert, they're both sort of doing kind of the same thing. There's no way the judge is going to kick their expert but not kick our expert, and so you might decide, hey, we kind of like our expert better than theirs, so we're happy to go in with both of them testifying. And then there's also situations where you might decide, hey, we think their expert can do us more good than harm. I would say this is a whole different presentation, but I think a lot of times people are a little too quick to think they need an expert. And sometimes it takes a simple case for one side and it turns it into a really complicated case. So it might be a lot of time on the defense side. I'm thrilled when the plaintiff hires an expert in an area, because by hiring an expert, they're sort of signaling to the jury, hey, you need an expert to decide this case. And then that can sort of turn it into a fight between experts. And that might be ground that we're much more comfortable fighting on. So figure out what your goals are. Are you trying to get this person excluded, or are you just trying to get the best answers and material out of them at the deposition, so that when this case does go to trial, they're locked in on certain things, they've affirmed certain principles or certain conclusions, maybe that your own expert has. And then this, under the new rule especially, but just focus, methodology. As Lucy said, there are a lot of experts who have, maybe they've gotten a little bit lazy with their report writing or their analysis. They've sort of, sailed through so many times in the past without really precisely connecting the dots. So what you need to do for an expert like that is really force them to explain what their methodology is, how it was derived, how it works, and then how it applies to the facts of this case, and how that methodology, you can basically draw a straight line from their methodology to the opinions that they're trying to offer in the case. Because a lot of the time with experts that are sort of trying to get away with something, at some point in that process, it just becomes very hazy, right? They can talk about the methodology, but then how does that actually flow through to your opinions? And they can say, well, in my experience, that's how it's done, or things of that nature. That's my opinion based on my professional experience, things of that nature. So really, hammer them on this point. Another good method for this kind of questioning is asking the expert, how different facts would have changed their opinion, right? So if they're saying, that this design was dangerous, force them to explain, okay, well, what would you need to see for you to conclude under this methodology that it wasn't dangerous, right? If they're attributing, if they're saying that someone deviated from the standard, ask them, how they arrived at that, and then what would need to change for their opinion to change, because a lot of the time the answer is that they don't know the answer to that, because they came up with the answer first and then sort of backed into the analysis. It's really important, especially if you're not thinking it's likely that you can exclude this expert, very important to establish common ground with them. Figure out, consulting with your expert, what do we need their side to affirm about our analysis and our conclusions. And so in getting ready for trial, knowing what their expert is going to push back on or not is very important, so that you're not kind of unnecessarily duking it out with the expert in front of the jury. You can stand up, you already know what they've already agreed to, and you can sort of rattle those things off as needed to support what your expert says. And then finally, I'll just go real quickly. This is a general point, but the order of your questions, that's something that I think about almost as much as I think about what I'm going to ask, is what order I'm going to ask the things. As I said before, experts are human. And so depending on which way you're going with them, if you sort of ask them the bottom line question up front, once they give you an answer on that, there's no force in the world that's going to get them to back off of that answer. But if instead you ask them a number of preliminary questions and are able to confront them or get them to admit that they're not too sure about those, they're going to be a lot weaker when you get to the ultimate question. And so a quick example, I had a case where someone had been designated as a human factors expert. But instead of asking him at the beginning of the deposition if he thought he was a human factors expert, I sort of showed him throughout the entire deposition that he didn't really know a lot about human factors and wasn't familiar with a lot of the studies and things of that nature. So then when we actually got to the end of the deposition and I said, can you just tell me, do you consider yourself to be an expert in human factors? And he said, no, I don't. But I'm very confident that if I just asked him out of the gate, are you a human factors expert? He would have said, oh, absolutely, I am. And nothing that I did after that would have really knocked him off of that. And then finally, there's a tendency during the depositions and, with courts hopefully paying more attention to Rule 702 motions, I think this becomes even more important. I know I have the tendency when I'm taking a deposition, and the expert gives me an answer I like, it's like I just robbed a bank and I want to get out of there as quickly as I can. But you sort of have to step back and think about in real time, how is this going to look in the deposition transcript? Did he just give me a clear enough answer? It might, once you get the expert to that point, you can usually reformulate your questions and sort of ask it in a summarized way and still get a good answer. And that's going to be much more effective when you're writing motions or even at trial, if you're confronting them or impeaching them with their deposition testimony. You don't want to have to go through 2 pages of transcript to show the jury or the judge that they ultimately agreed with your conclusion. You want to have that in a nice tight soundbite. So here's just an example. Asking this expert who was on industry standards in the motor vehicle or the commercial motor vehicle industry. And I, asked him to confirm that in the past 5 years, the hundreds of times he's been deposed, every single time he said that either the driver did something wrong or the commercial motor vehicle carrier did something wrong. And he gave me a real nice correct. What you don't see is that took a number of pages, because when I asked the question the first time, he pushed back here and there. He disagreed with something. He said, oh, no, that's not true. But I sort of eventually wore him down and then was able to get him to give me this answer, which obviously is a lot easier to digest, both to the court and then also to a jury. So Lucy, sorry that went long, but please go ahead with defending depositions.
Yeah, just a few practice points that are going to be more important than ever with the revised rule. One, enlist your experts early and ask them what material they need so that you can get it in discovery. I always try and ask my experts what document requests should we be issuing, what interrogatories would be helpful to you, and have them review documents early so they can tell me this is not it. I need this other type of document. Another thing, particularly if you're in-house, recognize that the client is going to need to give your expert information. And so for folks who are in-house, think about that you might have to gear your people up early to collect data for the expert to review and to have plenty of time for those processes to run and to get all the information they need so that they do have that support they're going to need to survive a Daubert challenge. With report writing, I think particularly if you don't get a Daubert hearing, we can expect that there will be more scrutiny on reports. So they need to be more detailed. They need to lay out the methodology. You need to look more carefully at that list of materials the expert relied on to make sure everything they relied on really is there. Sometimes I think if it's a new expert, ask for copies of their past reports if they can give them to you so you can see what type of the report they write. And if it's not really what you have in mind, maybe give them an outline. Like, we want a section on methodology. We want this section to help them really put that together effectively. Deposition preparation timing for your expert. I always like to do a session well in advance of the deposition so that when we're going through the report and we're discussing what's happened in the case, almost inevitably we discover something in the report we want to tweak, or there's a new fact we've learned, new discovery we've gotten, and we need to incorporate that into the analysis. So if you're doing that preparation, a month in advance or at least weeks, it gives your expert time to, draft an amendment to their report. If necessary, you can submit it to the other side and they can question your expert on it, so you don't get any challenges trying to exclude the new analysis, or at the very minimum, they can bring the new analysis to the deposition, and generally judges will find if they do that, then it's fair game and the other side has not been prejudiced, fair or not. Finally, when you're prepping your expert for a deposition, it is helpful to say things that will help them relax and to emphasize that they need to do their job, but they don't need to carry the weight of the whole case. And in fact, that you do not want them to carry the weight of the whole case. I think it's important to make experts understand they do not need to go out on a limb. You're asking them to testify on very specific things. And if it's beyond the scope, they can say, they don't know. Some other tips for defending expert depositions. You always want to make sure your expert is consistent with your other experts on the case. When judges are trying to decide reliability challenges, they frequently look to where various experts agree or where various experts disagree. So if you have another expert on your side who says something that is inadvertently critical of one of your experts, such that it accords with the other side's criticism, a judge will frequently seize on that and say, clearly this is unreliable. Their own alternate expert agrees. It's important to help your expert understand what Rule 702 requires. And I think also with defending expert depositions, you need to make sure, in some ways, put on your plaintiff's hat because you are proffering the expert, and make sure they understand they've got to explain their answers. We had a recent case where we were deposing an expert and we kept asking him, what was your methodology here? What did you rely on to reach this conclusion and things like that? And all he would say over and over again was, my experience, my experience, my experience. Answers like that may not survive a 702 challenge these days. So you've got to explain to your expert, you're the expert, you can't just be taciturn. That might work okay for a fact witness, but not for the expert. And finally, you should consider doing a planned redirect. Again, if you don't get a Rule 702 or Daubert hearing, this might be the judge's only chance to see what your expert has to say if they are challenged. And so, you may need to ask a fairly substantive series of questions at the end of deposition of your own expert in order to get the good testimony and connect the dots that you need so that they survive that challenge. Brian, did you want to talk about motion strategies?
Sure, and I'll be very brief, I promise. As I said at the beginning, this revised Rule 702 is meant to be a not so gentle wake-up call to a lot of district courts who had been misapplying, in the committee's view, Rule 702 for many years. And so if you have a template for a Rule 702 brief that you have used in the past, you should not at all assume that that is still useful now. I think for a while, judges are going to assume that, these are no big deal. They're just clarifying revisions. And for those of you who are filing Rule 702 motions, we need to really emphasize that the rule has changed in a way that is meant to correct previous misapplications. And so, judge, whatever you think the law used to be, you need to understand that the rule has changed in a way that requires you to approach this differently. Don't let your judges assume that this is business as usual. You need to use the helpful language from the advisory committee notes, use the helpful language from very recent cases applying it to drive home the point that this is a new rule and it needs to be applied with a set of fresh eyes. Second, the flip side of that is that there are just enormous amounts of encrusted bad Rule 702 cases out there. And part of what I anticipate is going to happen is that proponents of expert witnesses, those who are opposing Rule 702 motions, are going to say, Judge, this is just like this old case from 2010, and you can just do the same thing. It's the same analysis. The committee says it's just clarifying. And those who are filing Rule 702 motions need to be very careful not to rely on cases that incorporate this bad case law, cases that assume that the reliability of an expert's bases and grounds is a matter of weight for the jury, not for admissibility. For cases that assume that the reliable application of a methodology is just a matter of weight, not admissibility. Those are the kinds of things that we're going to have to be very careful to root out when we're looking at cases applying this new revised Rule 702. And last, this is just the same key that both Greg and Lucy have been hitting all along, that you need to look carefully at each of those requirements. And I should add helpfulness in there as well, which is also subject to this new clarified burden of proof. And just make sure when you're analyzing the expert that you're trying to have excluded, you make sure that you have arguments, if appropriate, as to each of sufficient basis, reliable methodology, and reliable application. And we can go to the next slide. And just very briefly, I'll touch on, each of us will touch on one of these. One area that I'm watching is how this cashes out with a particular kind of damages expert. I work a lot in the world of consumer class actions. And so one of the damages theories that we come across all the time relates to something called conjoint analysis, which is a way of using consumer surveys to try to derive a market price for a feature or a defect, as the case may be. There are some courts that have said that an expert that doesn't really pay much attention to how the supply side of the universe would work if a product doesn't have a defect or if a product doesn't have a certain feature. And our argument on the defense side for a long time has been that's not a reliable way to calculate a market price. A market price has to consider consumer demand, which conjoint surveys might sometimes be an appropriate way of measuring, but also the supply side. What are the factors that sellers and manufacturers are looking at? And so I'm curious to see how courts are going to treat, under the revised rule, conjoint analysis that does not do a reliable job of addressing the supply side of the market price calculation.
An area I am certainly watching is survey experts in intellectual property cases. Survey experts, particularly in trademark cases, have sort of sprung up, and the validity of the surveys is largely judged by how courts have decided on the surveys. Courts, they're in fact often the type of survey is named after the court case that first accepted it. And I think it's very much an open question whether that type of analysis survives a revised 702 all the time, where you're supposed to have sort of you're supposed to prove reliability to a higher standard, or at least the standard that should have been applied all along. Is it enough that a judge previously admitted this type of survey? Probably not. I think it also calls into question people who are offered as experts on legal concepts. Are judges going to sort of analyze these experts and essentially decide whether or not they agree with them, and cite the revised rule as their basis for doing so?
Great. Yeah. And then, this is, in candor, this is total wish casting, but we see a lot of experts on industry standards, and that seems like a not so fancy way of just saying, well, in my opinion, this is how businesses should or should not do this. And so my hope would be that under the new Rule 702, those would get a closer look. And as Brian talked about, in the past, some courts, it was sort of like you'd have to show that their opinion on industry standards just had no basis in reality whatsoever. And hopefully under the new standard, courts will be a little bit more discriminating. So I know we went long. We can certainly stick around for a couple minutes if anyone has questions, but we really appreciate you all logging in, and hopefully this was helpful. And thank you to Brian and to Lucy for their great insights.